For any of those people who can't make it today, we'll be recording this session. And again, good morning. Thank you for joining us. My name is Jonathan, and this is my associate, Sarah Mills. And we will be talking today about a variety of employment law issues, including the breaking news that has just occurred yesterday afternoon. You know, the news actually took me by surprise. I was on the phone really all day yesterday, and a client of ours had emailed me and said, "Hey, did you hear about this?" So, you know, employment law is always changing, and so we're always happy to answer any questions. So, just as an overview today, you know, we have a question and answer feature in the within Zoom here. There's also a chat that you can ask questions directly, but I think the Q&A section is a little better. And yes, like I said, we're recording this session and we'll place it online if you wanted to share it with someone or to watch it later. So we do have our PowerPoint here. I'll put that on. And I'm working with two screens, so if you see me look over here, that's why. So yes, the two topics we want to talk about today in our hour-long session is employment standards, liability, and reasonable notice updates over the past year, in the year 2021. And so to get right into it, so we don't delay any further. So really, yeah, those are the three things that we want to talk about. We want to start with the COVID leave, which has, if you haven't heard already, it has just been extended. We're going to talk about notice of termination within the COVID period and some other important cases. And if we have time, we might touch upon a few other topics. So the breaking news, to get right into it, Sarah, why don't you share the details of the press release yesterday?
Sure. So the Ontario government released a press release yesterday, importantly stating two things. Number one is that the COVID-19 period, as designated under the ESA, has now been extended. So it's been extended until July 30th of 2020. And the second major update is that the 3 paid sick days in relation to COVID-19 will continue to be available to employees until the same date, being July 30th of 2022. Now, it's important to note here that while the government has extended these periods, they have not expanded the rights in terms of the number of days provided to employees. So employees will still only be entitled to a maximum of 3 paid days in relation to COVID-19. So that could be for various reasons due to getting the vaccine, facilitating the vaccine for dependents or children or other family members. It could also be a side effect from the vaccine or, in fact, unfortunately, having COVID-19 itself. So all of those circumstances would qualify for a paid sick day, and that is up to $200 per day for a maximum of 3 days. And it's important to note that employers can apply to the Wsib for reimbursement of these payments to employees. So
right,
those
right.
are the
That's a lot, right? It was a very short press release in the middle of the afternoon. Like I said, I was on the phone all day yesterday. And someone had alerted me to it. So, you know, we expected, I mean, I can only speak for myself, possibly for you. I mean, Sarah and I, we will always talk about these issues. And we had said, you know, I wonder if the government is going to extend it. Back in September 2020, those who have been following along, they will remember that the dates were extended with about 48 hours notice before the end. So for today's presentation, Sarah and I were going to talk about, well, how do we prepare for the end of the COVID-19 period? You know, if there are any employees who are on an unpaid leave, how do we bring them back? Do we think about termination? How do we bring them back? Of course, it's not necessary to deal with that right now since it's been pushed back to, and I apologize, I made a mistake. It's not July 31st, it's July 30th, as Sarah pointed out. And I think that's the government's indication. You know, we are still in this COVID period. COVID is not over. We are not, you know, we are not, you know, near the end. And I think the fact that they extended it for 7 months, you know, till the end of July is also telling. Other extensions they've done 2 or 3 months at a time. You know, in September 2020, they did 3 months. So this is a longer one. So it's an indication that the government says, okay, we know employers need more time. We have two questions that have just come in and they're about the same. So I'll answer them now. About the sick days, the questions are, is it a total of 3 days or is it 3 additional days? Or really, and I think the other question that goes with it is, well, if it's a new calendar year, do the 3 days reset? So the law, the details of the law, as far as I have read from the press release, it is not 3 additional days. It is the same 3 days that have been available to employees since the spring of 2021. Now, the law hasn't been updated yet. The government has been making these announcements through a press release. I don't know if the minister was on in front of the media. So we can confirm exactly what the details are once the law has been updated. All we're going on right now is a 4-paragraph press release and some comments from the minister. So as soon as we see the Employment Standards Act is updated, we will send an email to all of our clients, and we have a special email list. If you'd like to be on that email list, just send us a quick email. We'll make sure you're on there. So from what I see now, it's just the government is, originally had said the paid sick days would end December 31st. From the press release, they're saying that expiry date for the reimbursable paid sick days is being pushed back to the end of July. That's what the press release says. And I should also confirm, paid sick days, it doesn't mean a full day of pay. It is either, or it is the lesser of $200 or the full amount of that employee's pay on that day. Partial days count as full days, right? And that's already made clear under the Employment Standards Act and the Employment Standards Guide that can be found online. So the paid sick days, just to confirm that, the expiry of those paid sick days was pushed back from December 31st to July 30th of 2022. So as far as I know, it's just allowing more employees to use the 3 days if they haven't. And there was some other, and just to kind of wrap this up, that one particular part, there's been some media attention that employees haven't been using it because employers can be reimbursed. So the government can track how much reimbursement they're giving for these very special paid sick days. And there hasn't been a lot of uptake. So this may be the government's indication to say, employees, if you need time off to take the vaccine, get the vaccine, you will receive some pay for that. So that's my comments on that. And of course, as we go on and as the Employment Standards Act is updated and the regulations updated, we will keep you posted. And then briefly in relation to COVID leave, we wanted to talk about the infectious disease emergency leave and just a quick overview of how it's been treated over the past 6 to 8 months. So Sarah, what's your overview on that?
Sure. So just touching briefly, we're all familiar now with the infectious disease emergency leave, which was originally enacted by the Ontario government on May 29th of 2020 at the beginning of the COVID-19 pandemic. And this is because many employers, due to the pandemic, had no choice but to lay off a number of their employees or to reduce their hours or wages as a result of COVID-19. Now, in normal times, these extended layoffs would have exceeded the temporary layoff provisions under the Employment Standards Act, being 13 weeks or a maximum of 35 weeks. And like I said, in normal course, any temporary layoff that exceeds those thresholds would be a deemed termination under the Act. And what that means is that employers would therefore be liable for termination and severance pay to these employees. However, IDEL changed that and essentially stated that employers who were forced to reduce their wages or employees' hours of work as a result of the COVID-19 pandemic could avail themselves of this emergency leave and place their employees on this temporary unpaid leave of absence without having these employees be deemed to be terminated. So what's clear from this regulation is that the leave is in fact not a layoff at all, and therefore it is not a deemed termination under the ESA.
And they also said it is not a constructive dismissal either, right? Those
specifically not a
words were written
constructive
directly
dismissal.
into the regulation. Yeah.
That's correct. But what question was left open was how this regulation affected constructive dismissals under the common law. So the common law is different from the ESA legislation. The common law is something that is decided by judges through our courts, and typically decisions are made based on precedent. So cases with similar facts are decided similarly. So when looking at constructive dismissal under the common law, we know that generally constructive dismissal occurs when an employer breaches an employment agreement with the employee, or it can be more subtle in terms of the employer substantially and unilaterally taking away employees' duties, reducing their pay, and making substantial changes to the terms of their employment. Now, constructive dismissals can also occur when employees are placed on a layoff that they did not consent to. So this is why employees that had been placed on the IDEL or IDEL leave were able to commence claims for constructive dismissal through the courts because this question was left open. Now, we have two lines of decisions that came out from the Ontario courts this summer. The first one that hit was the Cutino versus Ocular Healthcare Center. Now, in this case, a plaintiff had been dismissed very early on in the pandemic, and this person decided to commence a civil claim through the courts for constructive dismissal. Now, the court found that the employee was not precluded from bringing the civil action for constructive dismissal despite being placed on this leave. The court held that the IDEL regulation did not change the common law with respect to constructive dismissals. Therefore, this case left open to employees the opportunity to claim constructive dismissal in the civil courts. Now, there was another decision that was released just a few months after this Cutino case, and it still came from the Ontario Superior Court from a different judge. And this judge came to the complete opposite conclusion. So similar to Cutino, the employee in this case had been dismissed at the start of the COVID-19 pandemic. And the court in this case found that the employee had not been laid off in March, as the employee had alleged, but in fact had been placed on a lawful leave of absence due to COVID-19, and therefore he was not constructively dismissed under the common law. Now, the court in Taylor really adopted more of a practical approach in terms of looking at the purpose of the legislation, and it held that it would be impractical to state that the ESA prevented an employee from commencing a claim through the courts. We also have the decision in Fogelman that came out just 2 weeks shy of the decision in Taylor, although the judge in this case did not have the benefit of viewing the Taylor decision. It ultimately sided with the judge in Cutino, stating that the IDEL regulation did not change the law of constructive dismissal under the common law. Now, the court in this case referred to section 8.1 of the ESA, which specifically states that no civil remedy against an employer shall be affected by any provision of the ESA. And the court said that this provision trumped the IDEL regulation, meaning that a layoff, even though it was permitted under the ESA, could still be a constructive dismissal under the common law and therefore attract damages. So what's clear is that we really don't have any straight and clear guidance from the courts on this issue yet. We do expect there to be further litigation on this issue. For instance, we know that Cutino is being appealed to the divisional court, and Taylor is also being appealed to the Court of Appeal. So we think it's very likely that the Supreme Court of Canada may have to weigh in on these decisions in order to set the record straight so employers know, does placing an employee on this IDEL leave constitute constructive dismissal under the common law? Right now, we still do not have a clear answer to that.
Yeah, I think you hit it on the nose. There's two lines of cases. depending on what judge you get for your matter, which the court decides, when they're planning, when matters are heard, you might get a judge who agrees with the Taylor case, and you might get a judge who agrees with a previous Cutino case. So yeah, we're really waiting for a higher level court. Court of Appeal, I think, will make a decision, probably, divisional court. Supreme Court, maybe, maybe not. It may affect, the entire country. It may not. They may refuse to hear it. But yeah, there is, the only thing that's clear is that there is no clarity on whether truly the unpaid leave of absence, where an employer was forced to do it because their revenue was, down significantly, was it an actual termination or was it a lawful leave of absence? So we'll address a question that's related to this. So Sarah, we can talk about it briefly. So someone has asked, have the courts addressed the improbable proposition that the regulation permits an employer to reduce wages while still requiring the employee to work regular full-time hours? So it's a very unique, I think it's a fantastic question, because there's some mentions in the regulation, just as a background, that says an employer can reduce the hours of an employee, and that's considered a leave of absence. But there's a couple mentions of the employer can also reduce wages of an employee, and that is also considered a leave of absence. But there's other language in the regulation that only talks about hours of work. So there is this, it's a very unique section of the regulation. From as far as I know, no court has dealt with that yet. So I mean, the short answer to that question is no, the courts haven't addressed it yet. I think there's going to be the right plaintiff with the right employer, or possibly the wrong employer with the right lawyers, who are going to find the right case to argue, that situation, which is, an employee, they're still required to work full time, but they have a 10 or 15% pay cut, but they still have to work full time. And the pay that they would have received, that's considered part of their leave of absence, but they're still required to work full time. So no, that very, very narrow issue has not been addressed by the courts yet, but we are waiting for it, because that's something we identified, a year and a half ago when IDEL was first created. So we are waiting with bated breath. So that's our update on ESA and COVID leave. We wanted to spend a little more time on it because the law was, it was announced that the law will be updated soon. But what we really want to talk about today are, we want to delve into these 4 cases just briefly, because we want to give, the people listening to this webinar with some more context on this very important question. How does COVID affect the termination notice period? Okay, so some context before we get into these cases. So when we talk about a reasonable notice period, what we're talking about is if there's an employee who does not have a written contract of employment, right? So there are no terms governing if the employer terminates, what entitlements, what are the employee's full entitlements. And we're also talking about employees who may have a written contract, but the termination clause is either found void by the court, or perhaps your employment lawyer will say, this termination clause isn't going to hold water, and it's likely that the clause is void, and so you can pretend it's not there. For those employees who have signed contracts, let's say that Sarah or I have prepared recently, and where there is an effective termination clause, reasonable notice is going to be governed by what is written in that clause. That clause might say you get X. The clause might say you get the minimums. The clause might say you get the minimum plus this. The clause might say you get 12 months no matter what. So it's very important, as we've been saying for the better part of 2 years, it's always important for employers to review their template contracts. If you just need to get one quickly out the door, it may end up costing you more. If that employee works for 2, 3, 4, 5 years, things are great, but something later happens down the road and the employer has to terminate. So it's always good to constantly look at the template contracts that you're using for new employees and also for existing employees. If you're giving a a raise or some other new benefit to an existing employee, it is always advisable to get them on a brand new updated contract and make sure you have that reviewed by an employment lawyer. So Sarah and I have collected these 4 cases. They're all from 2021 because this is obviously a novel issue. So we wanted to go into the reasons why an employee who is terminated within COVID, the COVID period, and as we mentioned before, it's now being extended till the end of July. So we're not out of this in any way, shape, or form. If an employee is terminated within COVID, how is the court going to treat that employee's entitlements and what entitlements may be awarded? So Sarah, do you want to go over kind of the general context of terminating an employee and then talk about the COVID aspect?
Sure. So as Jonathan touched on with respect to wrongful dismissal, there are a number of factors that the courts consider with respect to determining the appropriate notice period that the employee should be entitled to for the termination of their employment. And the courts still rely on a decision from the 1960s, which was the Bardell and Global Mail case. Those factors are still considered today, and those are the employee's age. So obviously more senior employees would be more likely entitled to a longer notice period. The second factor is the character of the employment. For example, were they a manager? What type of duties did this person perform? And number 3 is the length of service that the employee provided with the company. So obviously longer servicing employees would be entitled to longer notice periods. Now, what we've noticed recently this year, as we have the COVID-19 cases start to come through our courts, is that we are seeing that the COVID-19 pandemic is also a factor that is being considered in terms of assessing employees' entitlements to reasonable notice and determining the length of that notice period. So let's start first with a decision that came out in January of 2020. So it was one of the first cases that came out this year, and that was Yi and Hudson's Bay. So this involves an employee who was terminated in August of 2019, so well before the COVID-19 pandemic had hit. This employee was 62 years old and had worked for over 11 years. And the employee tried to claim that he was entitled to an enhanced notice period because of the impact that the pandemic had in March of 2020 when he was still looking for a job. Now, the court declined to award an extended notice period to this individual because it determines that what's relevant is looking at the circumstances at the time of termination. So in August of 2019, when this individual was terminated, the economy was still fairly strong and employment opportunities were plenty. So really the COVID-19 pandemic didn't really have any impact or shouldn't have had any significant impact on this employee's obligation to find alternative work. And therefore the court declined to extend his notice period based on the COVID-19 pandemic. Now, we also saw that in—
Well, actually, Sarah, I just wanted to provide one comment on that one. And I think I would stress this important part, right? When a court looks at a termination, they're going to look at the circumstances, like Sarah said, that they want to put them, the judge will put themselves in the shoes of the employer and the employee at the time of termination, right? Because no one has a crystal ball. Judges have repeated this, in their decisions. No one knows exactly what's going to happen after an employee is terminated, okay? But at that time, what did they know? At that time, what is reasonable? That's what a judge will ask. And of course, like Sarah said, if you have a 62-year-old director who's worked for 11 and a half years, close to 12 years, that employee received 16 months of notice of termination, but it was not increased because those 16 months some of those 16 months happened to fall into COVID because the employer had no idea that COVID would have affected that, right? COVID may not even have existed in April 2019. But Sarah, you want to talk about the next case, Kraft versus Firepower, Kraft and Firepower Financial.
Sure. So in Kraft, the circumstances of this case involved a 34-year-old employee who was terminated at the very beginning of the pandemic in March of 2020. Now, this employee had 5 years of service at the time of his termination. He brought a motion for summary judgment and argued that he should be entitled to 10 months of reasonable notice. And he argued that it took him a very long time to find new employment due to the economic downturn that the COVID-19 pandemic had caused. And in fact, the court agreed with him, and they awarded him exactly what he asked for, which was 10 months. Now, it was based on 9 months reasonable notice, and the court noted explicitly that it was adding 1 month of pay, additional pay or notice, to this employee for the impact that the COVID-19 pandemic had on him. Now, it's important to note here, and we'll speak a little bit later about employees' duty to mitigate their damages as they claim wrongful dismissal. In this case, it was clear that the employee had done everything he could to mitigate his damages, including applying to over 70 jobs within a 13-month period. So it is definitely clear from this decision that the courts will absolutely consider the impact COVID-19 pandemic has had on employees looking for work. And in this case, we know that the value of that was an additional 1 month.
Right, and let's clarify. The person had worked for 5 years. They were 34 years old. In my opinion, in the eyes of the court, 34-year-old employees is quite young. And I think a 34-year-old employee would receive less notice than someone who is 54 or 64. Okay, but the court awarded 10 months. So they must have been more senior in their role.
Yes.
And of course, they had looked for 13 months for a job. They had proof of that they applied for 70 jobs and didn't find a job. And they were awarded 10 months, well, 9 months for a 5-year employee at 34 years old. And then, like Sarah said, plus an additional 1 month. So without COVID, they would have got 9 months. Because of COVID, they got an extra 1 month. I'm not sure, I can't do the percentage calculation in my head, but that's a bit of an increase, right? Yeah.
Absolutely. And so if we look at the FLAC decision, this more coincides with the Yee decision because this employee in FLAC was terminated in January of 2020. So again, we're contrasting terminations that occurred before the pandemic and after the pandemic. So this person was terminated in January, so a few months before the start of the pandemic. And the plaintiff tried to argue that he should be entitled to an increased notice period as a result of the COVID-19 pandemic. However, the court disagreed and again reiterated that you must look at the circumstances at the time of termination. And at the time of termination, there was no economic downturn. COVID-19 was not yet on our radar. Therefore, this employee was not entitled to an extended notice period. And again, we contrast this with Pavlov. And in this decision versus the New Zealand and Australian Lamb Company, we had a 47-year-old director of marketing with just under 3 years of service, and he was terminated in May of 2020, so after the pandemic had arisen. And in this case, the court held that the employee was entitled to 10 months of reasonable notice. And it determines that the uncertainties as a result of the COVID-19 pandemic were certainly a factor that were going to hinder this plaintiff's ability to find new employment, and therefore it offered a few additional months. So in this case, again, we have an employee who had worked for 3 years and received 10 months of reasonable notice. And we know for sure that COVID-19 pandemic was a big factor in the judge determining this was the reasonable notice period in this case.
Right. For that New Zealand case, Sarah, what was the original notice period and what was it increased by? Did the judge make that very clear?
The judge didn't make that very clear. It can also considered his age, character of employment, and length of service, and COVID-19. So we know that he probably added an additional 2 to 3 months for the COVID-19 pandemic.
Right, but that judge didn't explicitly say. So again, this is the difference there are various judges of the Superior Court, honorable judges of the Superior Court. Some of them in their written decisions will say, I award this much plus this much for COVID. So they've actually determined, because of the pandemic, this is what I would award this person, like we talked about in the Kraft case. But for Pavlov New Zealand Australian Land Company, the court just said, I'm going to look at it overall. I'm going to take, all of the factors into account, and including COVID, and this is the amount I would give. Right. So that judge in Pavlov in New Zealand did not say, I'm going to give this much and then plus additional amounts. So it's, we're trying to get into the mind of this, the neutral party who is, deciding the matter for the plaintiff and the defendant, the employer and employee. But it's not exactly clear. Did the pandemic, was it a more important factor? Was it a less important factor? For that case, the Pavlov case, they're 47 years old, director of marketing communications, under 3 years of service. Under 3 years of service. And apparently that person had earned, and I want to thank Sarah for her notes on this case, because she prepared the notes on this case. That person had earned $132,000 per year as director of marketing communications. So under 3 years of service, 47, in my opinion, 47, probably the court would say that is middle age, I would say. Right? I would say that, in my opinion, someone who's 47, it doesn't increase or decrease the length of notice. Right? I would say it's not that important of a factor, but the character of employment probably was an important factor. How much weight did that judge provide to that factor? We don't know. How much weight did they provide to the pandemic? We don't know. What we know is that 47-year-old, less than 3-year employee who was director of marketing communication, earning $132K, they received 10 months of notice. So judges have repeated it numerous times. The determination of reasonable notice is more of an art than a science. You will hear, I'm sure you'll read online, some people say, well, it's approximately 1 month per year of service. There is nothing really etched into the common law that says for every completed year of service, you get 1 month or 4 weeks or 4.5 weeks. It's a guideline that guides judges, but it is not written in stone. And this is an example. I mean, even if we go back, Sarah, let's go back to Flack. I don't want to give you a lot of flack for the Flack case, but that person was 61, a finance manager with only 9 months of service. Okay. And they were terminated January 2020. So they worked most of 2019, not all of it. That employee, finance manager at a car dealership, 2 months. So they had not completed a year of service, but they still received 2 months. And that judge, Sarah, correct me if I'm wrong, that judge said COVID did not play a role.
That's correct.
Right? COVID did not play a role. So that's an example. Clients ask us all the time, we want to terminate an employee. What's the amount of reasonable notice? These are the kind of the discussions that we have within our offices and on the phone. Even if you look at Kraft, let's just go back to that one. Again, it was a very recent case, terminated March 2020, March 10th, 2020, which I believe it was on the 13th, the WHO declared the pandemic. 5 years of service, 34 years old. They received, correct me if I'm wrong, 10 months. Yes. Well, it was 9 months plus 1 month for COVID. So 5-year employee, 34 years old, 9 months. This 1 month per year of service, when you look at these cases, we can call it a guideline, but I would say it's not the best guideline out there, because a 34-year-old 5-year worker got 9 months plus 1 month for COVID. And then just to talk about Yi, Hudson's Bay, that person had 11 and a half years of service, 62 years old, director of product development, 16 months. So if we look at 1 month per year of service, it wouldn't really be apt. right? And like Sarah said at the very beginning, courts will look at, those three very important factors: age, type of employment, length of employment. But there's actually like a longer list of all the different types of factors that could affect the notice period. And it's always based on the specific facts. One that comes up a lot is inducement. If an employer induces an employee to leave a comfortable employment, they work for 5 years, terminate them later, that could be a factor to increase notice periods. So we wanted to give you a taste of what judges have been saying in relation to COVID and terminating an employee during COVID. What I want to talk about next is, we have a little bit of time left. And of course, if you have any questions, feel free to put them in the chat. Feel free to put them in the question and answer, and we will get to them. We wanted to talk about these other updates based on, cases that have been released and decided in 2021. So the first one is with regards to moral damages, and there's a case called Russell and the Brick Warehouse. So Sarah, what happened to this employee and the employer, the Brick?
So this was definitely a noteworthy case because the employee in this case was a 57-year-old senior supervisor making $75,000 per year at the Brick, and he had been employed there for 36 years, so a substantial period of time. Now he was terminated, and the judge ended up awarding this individual 24 months of reasonable notice, which we generally say is the highest that can be awarded, although we have seen some cases exceed the 24-month threshold. But what's interesting in this case is the employee was also awarded $25,000 for moral damages. And this was because of the way in which the employee was terminated. So the court came to the conclusion that the employee was terminated in bad faith, and that the employer had not met its duty of common law duties of fair dealings and good faith in terms of terminating this employee. So what happened was the moral damages applied really to the manner of dismissal in this case. So seemingly this was an upstanding employer for the vast majority of his employment, but made a few errors in terms of the actual termination of this employee. So number one is the termination package that the employer offered this dismissed employee did not even meet his ESA minimum requirements. Number two, they did not provide him with vacation pay for his statutory notice period, which of course is required under the ESA. And number three, it took this employer over 7 months to pay this employee his ESA minimum termination entitlements. So the court determined that the employer had engaged in bad faith in terms of dealing with this employee at the time of his termination, and therefore awarded $25,000 as moral damages. So this is definitely a lesson to be learned for employers. When you're terminating employees, you need to make sure, number one, you're following the employment contract. You need to make sure you're following the ESA, but also do not forget that employers have common law obligations as well to treat their employee in good faith and engage in fair dealings with their employees at the, throughout their employment and at the time of termination.
Yeah, that's it's a warning, right? I think that's yes. One of these cases, and moral damages can be awarded for a variety of reasons. One of the reasons is to send a message to other employers, including that employer, but to other employers, right? And Sarah, I think you addressed, the most salient points. Treating employees fairly while they're employed, including at the time of termination and right after, is important for employers to keep in mind. We have some other cases we wanted to go over. Sarah, there was a case, again, from this year that we had talked about the circumstances for terminating an employee and the circumstances for determining how much notice they're entitled to. So I'll discuss this case. It was a case called Curry and Nylene, Canada, from this year. And the crux of the case is the employee was entitled to more than 24 months, more than that cap of 24 months that Sarah mentioned before, that the Court of Appeal says is the maximum that an employee can receive. Right? I'll just quickly go back to that. The other case we talked about, a 36-year employee received 24 months. So again, this 1 month per year of service, is it a good guideline? Maybe, maybe not. But that employee did not receive 1 month per year of service, is probably maybe 75%, 3 weeks per year of service, somewhere around there. But there are some circumstances that the Court of Appeal has said where an employee could receive more than this notional cap of 2 years. So what this court said in this case that was decided this year, they looked at that and they said this was a case where an employee should receive greater than 24 months. So this was someone who had been working for a long time, working there for over 30 years, with one company, and then their employment was continued through a company that bought that other company, and this person had worked for 39 years in total, right? And the court recognizes, an employee works for 39 years for one company. They have worked for that one employer their entire career. They only know that employer, right? They probably haven't applied for a job online, in ever, right? And the court has recognized, and not just in this case, Curry and Eileen, but in other cases where an employee has an exceptionally long career at one employer, that is a special circumstance that would increase the notice period past this notional 24 months. This employee received 26 months for having worked in total for 39 years. She was 58 years old at the time of termination. Perhaps she wanted to work longer, perhaps not, but you work for someone for 40 years. She started in 1979. The work landscape, as the court mentioned, evolved significantly since that point. And that employee was entitled to an amount of 26 months greater than this 24-month cap. There's a quick question. I'll address that really quickly. Has the Russell and Brick case been reported? It has. It's I'll type it in here. 2021 ONSC 4822 for any lawyers who are watching here. Go on Canley or Westlaw to get that case. The next case we want to talk about. Oh yes, this one was actually in the past few months. Terminating an employee who is pregnant. Okay, we've already done a webinar on human rights. And I'm sure we'll do another one very soon because it's a topic that's constantly evolving. But Sarah, why don't you tell our guests about this special case, Nahum and Honeycomb Hospitality, and dealing with an employee who was terminated who happened to be pregnant?
Sure. So in this case, we had a 28-year-old employee who had been employed for approximately 4 months. Now she was 5 months pregnant at the time she was terminated. And the court determined, it ended up in a wrongful dismissal action through the courts. And the court found that this employee should be entitled to an enhanced notice period due to the significant factor of her being pregnant at the time of her termination. And the court viewed this as being a bit of a barrier in terms of finding new employment, and therefore determined that she was entitled to 5 months of reasonable notice. Now, if we go back to, like we said, the general principle of 1 month per year of service, which isn't always followed, it's definitely significant in this case that an employee with only 4 months of employment was awarded with 5 months of reasonable notice damages. So it's certainly clear that pregnancy is definitely another factor that the courts will consider in assessing an appropriate notice period for dismissed employees.
Right, and let's be clear in this one. This was not related to the employee was terminated because she was pregnant, right? That was not part of this decision. It was not, as far as I know, although I would stand to be corrected. This is absent of an allegation of that pregnancy was the reason she was terminated. This is simply a judge saying, another one of these special circumstances that may elongate a reasonable notice period of termination is if at the time of termination, the employer knew the employee was pregnant, okay? again, we're not talking about whether that was a factor, and we can probably do another seminar related to, can you terminate a pregnant employee? I mean, the short answer is yes, as long as pregnancy has the employee's pregnancy has absolutely no bearing on the termination, and frankly, if the employer can prove it. I mean, if an employer goes bankrupt and has to terminate every employee, unfortunately, and they happen to terminate an employee who's pregnant, or they happen to terminate an employee who is on a medical leave of absence, I think an employer would have an easier time proving that no, the pregnancy, the leave of absence, someone's race, someone's sexual orientation was not a factor in that termination. So this is the another special circumstance that at the time of termination, what did the employer know and what is reasonable in those circumstances? Okay. Sarah, why don't you talk about the next case? This is a 2021 case, of course, and this is, as you mentioned before, mitigation. So I'll set the stage for you, and then you can talk about the case. So any employee who believes they're entitled to, common law reasonable notice of termination, like I said, maybe it's that 1 month of pay per year of service, maybe it's more, maybe it's less. That employee also has an obligation to show proof that they have been trying to find a similar job or another job, and they haven't been able to replace the income that they would have received, but for the termination. And for that reason, they should be paid, their notice of termination, or pay in lieu of notice of termination. So we call that mitigation. We call that an employee, has a duty to, mitigate their position, try and find new work. So in this case, which is Lake and La Presse, what happened in that case?
So in that case, we had an employee who was 52 years old at the time of her termination, and she had been employed for just over 5 years. Now, in this case, as Jonathan just indicated, well, in all cases, employees have a legal obligation to mitigate their damages as much as reasonably possible. Now, employers have the burden of proving that dismissed employees did not adequately mitigate their damages. And when this can be proved, we've seen the courts reduce the notice period or even eliminate the notice period for employees who have failed to properly mitigate. And in this case, it was held by the judge that the employee failed to properly mitigate her damages based on the following reasons. So number one, the court felt that she waited too long to commence her job search. Number two, she applied to too few of jobs. She didn't send out enough job applications in the court's opinion. And number two, when she was employed, she was a general manager. Now, when she was applying for new employment with other companies, she was applying for higher level executive or vice president positions, which the court thought was fine, but she should have also been applying for jobs that were more comparable to the job that she had just had. So in this case, the court held that the employee's notice period should be reduced from 10 months to 8 months in this case. So we can see because of the employee's failure to mitigate, that 2 months reasonable notice were deducted ultimately from her award for damages.
Oh, sorry, I just wanted to confirm. It was 10 to 8 or was it 8 to 6?
I think it was 8 to 6. I'm sorry.
Okay. No, and that's important. So let's clarify.
Reduced by 2 months.
Right. So it was reduced by 2 months, but this was an employee 52 at the time of termination. They were terminated. This doesn't have to do with COVID, but this is just kind of generally. They'd worked for 5.5 years, 52 at the time of employment, and they were a more senior employee. And so they would have received 8 months of pay, but they actually received 6, right? The judge reduced the amount of notice because the employer was successful in proving that the employee could have done a better job to try and find a new employment or similar employment, but she didn't. And I have to say, I'll echo something else Sarah said. It is the employer's burden to prove whether the employee did a good enough job to find a new job while, and usually it's while litigation is ongoing. So, there are always strategies on both sides that any side can employ to ensure that the employee is doing what they're supposed to do, or to start collecting evidence that the employee perhaps is not doing what they're supposed to do in terms of mitigation. And this is it's again a warning for employers and employees. For employers, if they want to prove that an employee didn't do a good enough job, these are the types of facts where a judge may accept that. And for an employee, they can't wait too long to find a new job, and they do have to have evidence that they've tried to find a new job. So those are other updates that we wanted to highlight kind of quickly for you. I hope we're not throwing too much at you here, but to kind of wrap up our talk today, and I want to be respectful of everyone's time. These are, we've already talked about the COVID-19 period being extended, but I wanted to just briefly touch upon the newest changes to the Employment Standards Act, Bill 27. Bill 27, you may have received an email from us detailing this, and it is now law in Ontario. And there's the 4 things that I wanted to highlight. So Sarah, do you want to take the first 2, and then I'll take the second 2?
Sure. So as most of you know, last week, the Bill 27 was passed, which is titled the Working for Workers Act. And this really enacted a number of pro-employee legislation. So number 1 is legislating a right to employees to disconnect. Now, this means that employees have the right to be free from the performance of work outside of normal working hours. So in other words, they do not have to be sending any electronic communications, responding to emails, phone calls outside of working hours. Mm-hmm. Now, this is going to apply to employers that have 25 or more employees at the beginning of any calendar year. So as of January 1st, if you have 25 or more employees, you are required to implement a written policy regarding the right for employees to disconnect. And these policies must be in place by March 1st of this year, of this upcoming year. So that's the first update. The second major update brought by this bill is a ban under the Employment Standards Act for non-compete clauses. So non-compete clauses, generally speaking, the courts didn't like them either. So it's really no surprise that we've moved to now a full ban. And generally speaking, non-compete clauses, they limit an employee's ability to find employment opportunities that compete with the business of their former employer. So it's limiting on employees looking for new employment. And essentially what the ESA has done is it's banned these non-compete agreements or clauses outright, although there will be some very limited exceptions regarding the sale of a business and for high executive level employees. Now, we have yet to see exactly what those exceptions, the extent of the exceptions, but we do know there will be very limited exceptions. We also know under the bill that temporary help agencies will be licensed. There's some changes to that, and employers are required to make available their washrooms for persons who are delivering to their company. So those are the major updates to Bill 27. And of course, as we get more information, we'll be sharing all of that information with you.
Yeah, Sarah, thanks. That was a really good highlight. I want to just supplement what you said. So first of all, the last 2 that you mentioned, for any temporary help agency, there's going to be a licensing process of those temporary help agencies. And any employer, of course, if you're an employer of a temporary help agency, it is top of mind, I'm sure. But if you are an employer who uses temp agencies, there will be, there are already some obligations on those employers to keep records. There will also be obligations to ensure that the temporary help agency that an average employer uses, that they know that the temporary help agency is licensed. Okay, so if you do use temporary help agencies, get in touch with us and we can guide you through, knowing that you are using the appropriate temporary help agency. And if you're a temporary help agency yourself, we're happy to assist with these new changes. And of course, delivery people in washrooms, for me, it's a no-brainer, but the law it's now in the law. Okay, and it's written into the law. Well, the Occupational Health and Safety Act, but it's written into the law that they should have access to, you know, restrooms, and I think that's quite reasonable. There have been some questions about the right to disconnect and the non-compete, so I'll answer those. So first of all, for the right to disconnect, it is a written policy that an employer must have, and the government's giving us 4 months to create the written policy. There will be more guidance given from the Ministry of Labor for what a proper right to disconnect policy will look like. So we will keep you updated on that. And the question that's come up is, well, those employees who carry around a phone to respond to customer needs, and they're compensated, I guess, only if they come in to support those customer needs. So that's I think the most important part of having this policy. It's to clarify what an employee is required to do based on their job duties, and what they're not required to do. So I think this new right to disconnect, it's also an opportunity for employers to take another look at the job duties of their employees. Because if an employee is on call, they should be compensated as such. If they have to be able to respond to customer concerns, let's say on a phone after hours, it should be clarified for that employee when they're going to be compensated. Because if an employee is working for an employer, they ought to be compensated for that. So it doesn't necessarily only have to be when they are only working, excuse me, from the employer's premises. An employer can work for an employee can work for an employer even if they're from home. I mean, COVID has shown us that. So if there are questions about on-call workers, we're happy to have a more detailed chat about that. Whether or not, and there's just a follow-up question to that, whether or not the employees are salaried or hourly, it doesn't matter. It doesn't matter. Now, what would matter is if they're managers. Okay, and there are, any employer in Ontario knows there are lots of exceptions for managers and supervisors, and of course they're not paid overtime pay. And there probably will be some more guidance given by the Ministry of Labor, given that this law was just passed last week, give more guidance about the other exceptions on the right to disconnect. And then lastly, talking about this non-compete, I'll emphasize this. It is a clause under the Employment Standards Act. It applies to employees and employees only. If you have a true independent contractor, and that's a loaded statement to say right at the end of our presentation, but if a worker is a true independent contractor, the principal can enter into a reasonable non-compete agreement for that contractor. Okay. Now, the longer story, and I'm always happy to have a more detailed conversation offline or over email. If you have a contractor, but they're more likely an employee, but you treat them like a contractor, it is very possible for that non-compete agreement to be overturned if the worker is found to be an employee and not an independent contractor. So it's probably a longer conversation I'm happy to have, and I know Sarah's happy to have as well, but we have to be careful with who we treat as independent contractors. If they are truly independent contractors, yes, let's apply a reasonable non-compete, reasonable non-solicit. If they are an employee, the non-competition agreements are banned. So on that note, I will say thank you to everyone. We very much appreciate you joining us for these various webinars that we've been putting on in the last few months, and we're going to continue that. So I encourage you to keep your eyes on our social media, and if you'd like your email added to our regular email, where we send important, but we try not to overwhelm people with too many emails, but when there are important changes like the one yesterday, we will send out an email so you're aware of that. So Sarah, any last words for our guests?
No, I think we've said a mouthful today, so hopefully we haven't bombarded you guys with too much information, but always just feel free to reach out to us if you have any questions on anything that we've stated here today. So we're happy to help.
Okay, thank you everyone for coming. Have a great day.
Thank you. Bye everyone. Bye.